So we'll be starting shortly. I've just sent the link to our guest for today. You're looking beautiful, as always.
You too.
Thank you.
The mentees are split into two groups.
Yes.
Okay.
Yes.
Okay, it's 10 o'clock now.
Okay.
So good morning, everybody. My name is Bernice Asien, and I'm a lawyer based in Lagos. I was a previous mentee of this mentorship program, so I'll be the anchor for today's program. So this program is recorded and live streamed on all our social media platforms. I'll go ahead to introduce the program now. Jiipcc Mentorship Program is an internship program that is organized quarterly for law students, young lawyers, and intellectual property enthusiasts across Africa. Mentees are afforded the opportunity to access valuable intellectual property advice, training, network, mentorship, internship, discussion forums, industry updates, resource material, and resource materials from experienced IP mentors. This program seeks to encourage the continuous intellectual property training, development, and evolution in Nigeria and Africa at large. You can watch our videos by searching the hashtag Jiipcc MIP mentorship program, and you'll see all our videos on YouTube and on Facebook. The objective of this program is to provide easy access to intellectual property guidance, training, and resource materials for students, young lawyers, and IP enthusiasts across Africa. Also to facilitate the dialogue and network among experienced and less experienced intellectual property practitioners and stakeholders. It also transforms mentees into intellectual property mentors and leaders for the next generation of mentees. It also facilitates further intellectual property mentorship, internship, and scholarship, and IP-related job placement for mentees. So we'll go on to the presentation now. I'll call on group 1 to make their presentation.
Okay, so who'll be presenting for group 1? You just have 5 minutes. So please let me know if you're ready. Sorry, group 3 and 4, I think. Group 3 and 4. Please just unmute yourself and begin your presentation. Group 3 and 4. Okay, if they are not here, let's just call Mr. Leonard so that he can start his presentation. Then probably when he's through, they can make their presentation. You're welcome, sir. Bernice, you can go ahead to read out his profile.
Issues, content. So our guest mentor for today is Mr. Leonard, Otuonye Ugbajah. I hope I got that right. He is a lawyer and an international development consultant with expertise in trade law and policy, regional integration, investment climate and market system reforms, competition, competition law and policy, and natural resource governance. He has been active in the public policy space in Nigeria for over 13 years. For over 13 years now, serving as a consultant and community member on a number of policy processes in Nigeria and West Africa. He has consulted for several development partners and international institutions, such as DFID, GIZ, UNIDO, the EU, ECDPM, the Presidential Enabling Business Environment Council, PEBEC, various MCDAs, National Assembly, Non-State Actors Coalition, etc. Mr. Leonard's engagement in the AFCFTA includes leading the writing of the report that advised the Nigerian government, that is the Federal Ministry of Industry, Trade and Investment, on issues around the ratification and implementation of the agreement, conducting a political economic analysis of Nigeria's participation in the agreement and regional integration as a whole. He served as a senior special assistant to the former governor of Imo State from 2019 to 2020 on ease of doing business. He was a member of the expanded state ESCO and several other committees such as Development Corporation, Investment, Pension Reforms, Tax Reforms, Public Procurement. He's also the founder and executive director of the Center for Trade and Business Environment Advocacy, which is presently engaged in research and advocacy towards the reform of intellectual property rights regime, among other trade and business environment related issues in Nigeria. He's also the principal consultant for TBE Advisory Limited. Mr. Leonard is a lawyer who holds a postgraduate certificate in competition law from the University of London and a master's degree in international affairs and strategic studies with focus on the interplay of powers and politics in international trade relations. He is a firm believer in the emergence of a great Nigeria and Africa and devotes his life to contributing to this cause. We are so pleased to have you, Mr. Leonard.
You're welcome, sir.
Thank you. Thank you. It definitely was not my intention to cause you to twist your tongue in the process of reading my profile. Yeah. Neither was it my intention to make you spend such a long time reading my profile. I thought it was just for record. Okay. Thank you very much for having me. Am I on? Can you hear me?
Yes, sir, we can hear you.
Can you hear me?
Yes, sir.
Okay. Let me apologize beforehand on the internet. Can you hear me? And my experience with the internet where I am hasn't been very wonderful. So I alternate between the hotel Wi-Fi and my mobile router. Hopefully between the two of them, we'll have a seamless session. Okay, maybe I should share a slide that I have prepared.
Okay, sir, you can do that.
Is that okay? Do I have a share access?
Yes, sir.
That I have prepared. Let me first thank team for the wonderful work you're doing and for inviting me to contribute this little piece of the work you're doing. And I'll give you a caveat, you know, for the okay. So, Juliana, I'm trade heavy and IPR light. So if you understand what that means. So I'm a core trade expert.
Okay, so I think probably he's having the network issue that he just spoke about.
Hello, Ma.
Welcome back, sir.
Okay. I think you should ask him to turn off his video. It will be better for the audio.
Okay, fine. Thank you.
Turn off your video,
I think
sir.
that's a brilliant idea.
Thank
Great.
you, sir.
Yes. So I started by saying thank you for putting this together and for inviting me to make this presentation. So I'm going to be speaking to the IPR issues from the perspective of what is happening within the AFCFTA at the moment. Can you see my screen?
Not yet, sir.
Okay. Can you see it now? So,
yes.
So I have the outline. I'll just try to set the context just to see it now. So, so I have what the issues or what the present scenario is with the IPR in Africa. Then I'll look at the IPR in the AFCFTA. What are the hurdles? What is the scope of the coverage? What are some of the pertinent issues? And then we'll look at the prospects. What should we look forward to? Then the constraining factors in the negotiations and conclusions. So as a general note, I don't know how many of us, how familiar we are with the AFCFTA. It is not on my slide, but I'll just spend a few minutes to give a general overview of the AFCFTA. Now, the African Continental Free Trade Area is what the agreement seeks to establish. So just a note on terminologies, especially because I imagine we are lawyers, so it's good for you to use the right expressions. So you have the agreement establishing the African Continental Free Trade Area, which is the shorthand is the AFCFTA agreement. Some people want to say it's after, but the acronym doesn't permit that, and I don't like to use that. So you have the agreement setting up the AFCFTA, which for shorthand we say is the AFCFTA agreement. The AFCFTA itself is a free trade area, and the agreement establishes a free trade area. Now, the agreement, the structure of the agreement is this. The purpose, first of all, that it wants to create a single market for trade in goods and services within Africa. And this is in line with what we call the Abuja Treaty, the Treaty of the African Economic Community of 1991, which was signed in Abuja, which set an agenda for all the African countries to
Let's hope that he joins us soon. It's actually in Lagos, and maybe they are having issues there because he was saying he's coming back to Abuja, and that's why we fixed the time for 10 a.m. So probably where he's located, the internet is poor there. But hopefully he'll be back soon.
Okay, ma'am.
Well, who are the groups? Who are the people that are supposed to present today? Group 3 and 4. Who is supposed to present for group 3 and who is supposed to present for group 4?
Okay, I'm supposed to present for group 4.
Yeah.
Okay. That's Grace. Okay. So Bernice, please note that Grace is presenting for group 4. What about group 3? Who is presenting for group 3?
Okay, hello. I think I'm back on.
Yes, sir, you're back.
Okay, so I just transferred to my phone. Maybe this will be better, but I'll still project the slide from my laptop. But I'll mute it.
Okay. Maybe you reduce the volume on one of the devices so that.
Yes, I've just muted the laptop now. So
okay. Thank you.
You're welcome. So I'll share the screen again. Done before there. Okay, so I was talking about the process of integration, and I talked about starting from the free trade area to the customs union, up onto the to the common market, to the monetary union, and then political union if you want. You know, so the idea is that in a free trade agreement, you eliminate all barriers, all tariff and non-tariff barriers to trade. So you eliminate import duties for goods originating from any of the member states and being exported or sold in another member state. So for example, between Nigeria and South Africa, under the AFCFTA, if a South African company is importing goods from Nigeria, they wouldn't have to pay duty, or they will have to pay duty based on the agreed tariff under the AFCFTA. And then apart from duty, it also eliminates non-tariff barriers, which are administrative procedures, either relating to customs procedures, relating to checks, to standard. Basically, those barriers that are not classified as tariff, but they can also hinder the flow of trade between two countries. So that's free trade area. But you move from there, and then you have the customs union, where the member states then harmonize their internal trade policies, their domestic trade policies, and adopt a common trade policy towards third member states. So what the key marker of a customs union is a common external tariff, where the countries then charge the same tariff, you know, for products originating from non-member states. Now, in West Africa, we have the ECOWAS, we have the ETLS, the ECOWAS Trade Liberalization Scheme, which is our free trade agreement. But now we have the customs union marked by the ECOWAS common external tariff. So now let's just leave it at that 2 level and say that AFCFTA is a free trade area that seeks to bring together the different regional economic communities like ECOWAS in West Africa, ECAS in Central Africa, EAC in Eastern Africa, SADC in Southern Africa. So the idea of the AFCFTA is to collapse the existing regional trading arrangements and to produce a harmonized continental trading arrangement that will encompass all the countries. Now, this is simplistic. It's quite more complex than this, but that's just the general idea. Now, within this same framework of AFCFTA, now the framers have decided to go beyond just trading goods to involve trade in services and various kinds of services, you know, including professional services that would affect some of us. And then to also include issues relating to investment, issues relating to competition policy, and issues relating to intellectual property rights. Now, the issues relating to investment policy, competition policy, and intellectual property rights are classified or are lumped under the phase 2 negotiations we just started a few months ago. So the issue of intellectual property rights is, well, they're just starting the negotiation on that. So what we'll be discussing today, we're basically thinking around what could come out of that negotiation eventually. So for a start, we're saying that you know, it's important for us to begin to think about the issues of knowledge governance, of innovation, who has access, who produces, who uses, and how it is used. And of course, we know at the core of intellectual property rights is balancing private interests and public interests. Private interests to reap the benefits, whether it is moral or economic, from an intellectual, arising from intellectual exertion, and then the public interest to reap also the benefits of that intellectual output, and then use it for the advancement of the society. So this is a conversation. It's not a new conversation in Africa, neither is it in the world or in Nigeria, any country for that matter. The AU has what they call the Pan-African Intellectual Property Organization. It's a new idea that the AU has that seeks to harmonize existing continental systems. Now, within Africa, and that's some of the issues we'll be examining subsequently, you have broadly speaking, two regional systems of intellectual property rights protection. One, broadly speaking, is for the Francophone, the other one is for the Anglophone. For the Francophone, you have the OAPI, and for the Anglophone, that's English speaking, you have the ARIPO. Now, these two systems have been existing, and they have their legacies in colonialism. There are post-colonial creations following after the patterns of the colonial governments of France and Britain, respectively. Now, beyond these ones, you also have regional systems, or regional efforts, because they are not full-blown IP administration systems. So there are harmonization frameworks at the regional level, whether it's at the ECOWAS level, at the SADC level, EAC level. If you look at their treaties and their protocols, they have provisions relating to how the member states of those regional configurations want to cooperate, harmonize, and better administer intellectual property rights within their domain. A remarkable thing about the OAPI and the ARIPO system is that they are supranational. And when you say supranational, it means that they have powers that supersede the powers of the state. They are regimes that can administer intellectual property rights on behalf of their member states. So, for example, they can do, you can make applications to them directly or through the national authorities. They can examine, they can register, and all that, Then, of course, they have ongoing cooperation framework among the two of them. Now, Nigeria is neither a party to the ARIPO nor the OAIP, but Nigeria is an observer Nigeria is an observer in ARIPO. So there are other AU processes and initiatives on IPR. For example, there's the African model legislation for the protection of rights of local communities, farmers and breeders, and for the regulation of access to biological resources, which was developed in 2000. As the name implies, model law is a soft law. It's for countries to adopt if they want. Unfortunately, the experience of the model law has not been positive, because many countries, not just that many countries in Africa, or that the countries of Africa have not adopted it. In fact, there's no non-country in Africa that have fashioned their IPR laws, especially on this protection of rights of plant varieties and breeders. No country has adopted this law, as their own modern national law. Rather, the African countries have gone ahead to adopt the UPOV system, which has been criticized as not being in interest of Africa. And some reasons have been adduced for this, external influence, and we'll get to those. We'll get to those eventually. So then there's a continental strategy for geographical indications in Africa. It's also another AU document. Then there is the African Union Strategic Guidelines for the coordinated implementation of the Nagoya Protocol. This is on biodiversity. And then there's the Science, Technology, and Innovation Strategy for Africa, and the Pan-African Intellectual Property Organization, which I just talked about. Now, what you notice is that all these instruments seek to devise a common front for Africa, both in terms of administering IPR at the national level, at the regional level, but also in formulating positions for negotiations when they go to the international institutions like WIPO, like WTO, or even WHO, where issues relating to health-related IPRs, patents, and that are topical. So what's the performance? The African Union released a study. It's an annual study called Assessing Regional Integration in Africa every year. So that of last year focused on the phase 2 negotiations of the IPR. And one of the interesting findings there is that you see that African countries collectively have the lowest share of global applications for intellectual property rights. And the gap between Africa and other regions is very high. Now, the total number of patents granted for residents in Africa in 2017 in the entire continent was 1,330. In the same year, patent offices in Latin America and the Caribbean granted 1,682 patents to residents compared to 592,508 in Asia and 16,000 thereabout in Europe. So you see the wide gap. So does it mean we're not innovating, we're not producing intellectual property in Africa? Does it mean people are not inventing things, Well, I'll leave you to judge that, Now, the gap between residents, or possibly people are not aware of the need for them to protect their intellectual property. That's another perspective to it. Now, the gap between resident and foreign applications is also significant. 29 out of 747 patent applications. So even the ones that we're saying were registered in Africa, many of them, or the majority of them, are non-resident. So that's like people owning the rights in other countries, but who want to seek a stronger protection in African countries, so they will come and register in Africa. So only 17 of them were filed by residents, which include foreign companies even based within the region covered by the organization. So that gap is there. Now, when we come to the AFCFTA, we say that the AFCFTA commits to the negotiation of intellectual property in phase 2. Now, if you look at the Article 4, that's where it provides for cooperation in investment, intellectual property rights, and competition policy. Interestingly, and which is going to underpin the rest of the discussions we'll be having for the next few minutes, is the fact that there's what we call the principle of acquis under international agreements, and basically it just says it's a principle that basically say we'll start or would take off, considering what has been achieved. So you use what has been achieved among the parties, as a foundation to build further cooperation or further harmonization and alignment. And in the case of the AFCFTA, the regional economic communities, which is the ECOWAS, SADC, ECAS, EAC, COMESA, all have existing processes, whether in trading goods, trading services, intellectual property, and all that, They have existing initiatives that seeks to harmonize, all of them at various levels of development, So the Article 19 of the AFCFTA has said in paragraph 2 that that the acquis, it establishes the acquis. So it has said that members of other regional economic communities, regional trading arrangements, and customs union, which have attained among themselves higher levels of regional integration than under this agreement, shall maintain such higher levels among themselves. Now, what should come to your mind first of all is, so in terms of say ARIPO, or the OAPI, they've attained a higher level of integration in intellectual property administration because they already even have, common registration and administration systems among them. Apart from the fact that they have already harmonized their laws. So does it mean then that the AFCFTA negotiations is not supposed to go below than what has been achieved in terms of harmonization or integration among themselves? That's number one. Then number two, they will be allowed to maintain that higher level of integration they already have among themselves. So if you look at also Article 5, the AFCFTA shall be governed by the following specific trade-related principles. So REX, free trade areas, which I've talked about, as building blocks. So they are the building blocks. Preservation of the acquis it's more or less talking about the same thing. Best practices in the REX, in the state parties and international convention binding the African Union. So when you talk about international convention, you have, for example, the WTO TRIPS, you have the various WIPO conventions and treaties and all that. So, and does it mean that countries within the AFCFTA cannot negotiate outside of these already existing frameworks at the regional and international level? That is something to consider. So some of the issues that will be that are paramount in this whole negotiation is the policy and institutional incoherence resulting. These are the things that are facing the negotiation, you know, that is making it look intractable in a way. The policy and institutional issues, policy and institutional incoherence existing, resulting from overlapping sub-regional IP organizations. I've talked about the sub-regional organizations, and the thing is that their rules are not yet harmonized, you know, and even though there are processes to harmonize those rules. So you have to grapple with both the policy and institutional incoherence. What powers are you going to allocate to those existing organizations at the end of the day, or do you want to scrap them, you know? So that's a big issue. Then there's also the harmonization challenges occasioned by the proliferation of IP of IP regimes, and here you also look at the misalignment with the continental overall goals, and by that, where these things are very obvious will be like in the issues of plant varieties protection, where most of the existing regimes within the region are tailored more after the 1991 UPOV as against, you know, the African model law that emphasizes the protection of the right of the farmers, the right of the communities, and the protection of indigenous or traditional knowledge. You know, those practices that farmers used to plant, replicate, select their seed, you know, and share the seed that have helped them over the years, over the generations, to maintain productivity at a certain level, you know, to feed themselves. That the existing frameworks are misaligned because they don't take into cognizance the peculiar African realities. So now there's also the issue of managing intellectual property rights in free trade agreements. So traditionally, whenever you bring intellectual property rights within a trade agreement, it raises a lot of issues. People tend to interpret it as the strong trying to muzzle their way, you know, to protect their own home countries against the weak. But in this case, we're looking at Africa to Africa. But the issue will still arise as to whether certain more advanced African countries, you know, would be the most beneficiaries of this kind of protocol in the AFCFTA. So this also requires managing the outlook of the negotiation from the perspective of the stakeholders in the member states. So what could be the scope? Now, seeing that traditionally IPR is territorial in application, you know, countries, you know, within all the international frameworks from the WIPO to the WTO, countries are allowed to establish their own systems of IPR protection, you know, based on the standards that are established within those frameworks. And in that case, what are we trying to achieve within that of the AFCFTA that we want to make it go continental? You know, so what we think negotiators should aim at would be to develop a cooperation framework that harmonizes the fragmented continental landscape. Now, some of the ingredients they could use to do this would be to focus on the development-oriented aspects of the intellectual property rights. Those issues that are not properly captured within the international frameworks, you know, but are of importance to Africa, given that we have a significant interest in agriculture. We have a significant interest in the creative industry. We have a significant interest in the emerging IT industry because of our emerging innovation hubs and startups. So there's need for clarification and convergence of the concept rules and exceptions where appropriate, and then the principle of variable geometry would assure that countries are able to meet up with the obligations based on a staggered timeline. So basically, in most trade agreements, you have different countries at different levels of development, and the principle of variable geometry would allow those countries to have some flexibilities. So for example, the developing countries under the least developed countries, LDCs, under the WTO, have an extended time frame up to June of this year to begin to implement the obligations arising from the TRIPS. That's in other parlance, you call it special and differential treatment given to them. So that would assure the least developed African countries or the poorer countries to that they will not be forced to apply some of these rules where they don't have the capacity to do so, or where it will be detrimental to their economy. But it will go through a phased process where they can then come into the application of them in a more relaxed or balanced manner. So now some of the substantial issues really, that the negotiations are faced with to determine, and I tell you, it's not a small work. Maybe perhaps this may be the most difficult part of the phase 2 negotiation, because if you look at the issues around investment and competition policy, they are fairly settled because you don't have fragmented regimes as much as you have in the IPR protocol or negotiations. So here, because of one, like I've said, the international agreements that many of the African countries have signed up to, whether they are bilateral, whether they are multilateral, signed up to, and when you talk about bilateral, the classical case is that of the SADC Economic Partnership Agreement with the EU, or whether you're looking at the existing regional frameworks within Africa. So because of this fragmentation one, and the fact also that most of the existing regional instruments are not tailored to meet African reality, in terms of the scope of their protection, the things they target at the rights they target at protecting, or just because of the way they are administered. So it's a very difficult thing to try to harmonize these various pieces. And at the end of this, just remind me, I'll post 2 materials that you could read and look at how, and that will expose you to how complex and the issues are. So now you have some of the questions, that are up for determination. And I must also mention at this point that you can also relate this to the ongoing conversation around reforming the intellectual property rights administration in Nigeria. My organization has done some work and some stakeholders engagement, and we're doing more of that on this issue. The idea is that Nigeria also has, but not in the sense of the African continent now, but in our own national sense, we have a fragmented system of IPR administration. So you have the commercial law department in the Ministry of Industry, Trade and Investment handling issues relating to patent and to trademarks and design, while you have the Nigerian Copyright Commission in the Ministry of Justice handling the issue of copyright, and then you also have NOTAB playing some interface role in the whole thing. So the conversation around reforming the IPR regime in Nigeria is basically, and I think there is a considerable consensus on this, to have an intellectual property rights commission, where we can then consolidate these various aspects of intellectual property rights. That's one string of it. The next string of it is this: can we then look at the substantive rules we have vis-a-vis our international obligations and vis-a-vis emerging realities? So, for example, how adequate is our regime when it comes to protection of softwares computer programs or computer-related inventions. Now, these are some of the issues. So when we are discussing this, just have it at the back of your mind, and I'm sure many of you may have engaged that process too, that the Nigerian IPR regime is in dire need of updating and total overhaul. And in the coming weeks, we'll be organizing a major policy dialogue around this. We are speaking with the stakeholders now, and we are partnering with the NESG to host a major dialogue on that issue so that we can move to the National Assembly and see what we can extract out of them in terms of a new law. So now, how do we address the liability of intermediaries for online copyright infringement? So we know about all the issues, who is responsible. You see what is happening in the EU now, you know, it's also happening in other countries. Who is responsible for infringement of online content? Is it the platform owner, or is it the person who has posted it on the platform, you know, and those kind of issues? Now, how do we address rather contested and emerging matters in the global IPR space? So protection of works generated by artificial intelligence, plant, animal, or human genome sequencing. You know how the DNA research has gone nuclear, you know, pun intended, you know, in these matters, nanotechnology or inventions made use in outer space. Also issues around regional exhaustion policy. Now, if you look at this and compare with the EU system, one of the tools that the EU has used to entrench the integration of their common market is the use of IP, of regional IP exhaustion within the EU. So that basically means that once you put it to the market within the EU, you know, it can circulate within all the countries. You can't say, okay, well, this is just for this Belgium, or for UK when they were still in the EU, or that. So we're seeing, and this is a topical issue also in Nigerian IPR landscape, whether you can allow parallel importation, or whether the owner of a right, for example, can prohibit the importation of that product within the same country, you know, or just by the mere fact of putting it to the market in that country has exhausted all patent rights to that invention. So, what of scope for cooperation on patent examination? Do we adopt the centralized registry kind of arrangement, or do we then say, okay, if you're applying in this country, maybe there should be notification to other countries within the region, you know, such that countries that have comments on that application could make their comments, of course, after examining it. So should there be a kind of framework for cooperation on patent examination, or do we set up a regional body, you know, even though not a registering authority, but of course they would now be able to examine every application that emanates from a member state and then make their comments on it before the member state would make the final decision as to whether to register or not. So those are the different issues. How do you want to capture issues relating to health or access to medicine, especially using the TRIPS flexibility, which, as a matter of fact, many African countries are not. But I think South Africa is basically about the only country in Africa that has used that in the days of the HIV AIDS crisis. But now there's also a lot of movement around this, even at the WTO, you know, with the South African Indian position on TRIPS waiver, which has received support even from the US. You know, now how can we ensure that developing countries, African countries, can use the TRIPS waiver, not TRIPS waiver, compulsory licensing to produce generic versions of medicine or drugs that have been put out in the market? Can we design a common regional framework? And of course, for you to do this, that means you have to ratify the truth agreement and domesticate it within your country. So how would the AFCFTA address this issue, especially in the light of the present COVID-19 crisis? That's an important question for us, for the protocol to address. Then, moving from that to the adoption of an agenda on plant breeders' rights regime that's suited to the local seed ecosystem and publicly funded agriculture research centers. I've talked about that before. So the question, and it's Adibola that posed this question, whether we should use the AFCFTA to move away from the UPOV regime. Is that possible? How practicable is it, especially given that many of the African systems for plant breeders' rights is already based on the UPOV system? Do we ask them to go and renegotiate? Maybe, or do we just adopt that? But that system has been shown not to be effective or suited to the need of Africa. So these are some of the other issues. Let me just run along. Then the institutional issue is important also. I've talked about it too. A centralized administration system, or should we retain a system of progressive harmonization, but then we set the standards or the principles that will guide that harmonization and timeline. And then we allow countries to harmonize their regimes over a period of time. Now, so what are some of the prospects? Look at the possible coverage of the IPR system within the AFCFTA. So you look at the two examples. This is what the OAPI has covered, and this is what the ARIPO has covered. And now if you merge the two of them, of course, taking away just the one I have merged yellow, which is, well, it's allowed, but it's not a core IPR provision, because you can use other laws relating to unfair competition to address that issue. So you have patents, utility models, trademarks, and service marks, industrial designs, trade names, and all that. So, but where it gets interesting is where it comes to traditional knowledge and expressions of folklores, because the international conventions that many of the African countries are party to do not cover these parts. And when you talk about indigenizing IPR regime or indigenizing IPR rules in Africa, then you should pay more attention to traditional knowledge and expressions of folklore, which are peculiar, not entirely, but which are peculiar and important to African countries, which don't receive much attention at the international level. So other issues, we want to you consider the issue of entrenching the principles of men and most favored nation treatment.
So I can see that he's still here, but we can't hear him again. Mr. Leonard, I think he's having the technical issue that he complained about. Well, I would like to acknowledge Mr. Ayokule Adetola. Thank you very much for joining us today.
Good morning.
Good morning. Thank you, sir. Okay, so I guess that Mr. Leonard will be joining us back once he's able to fix his internet. While we wait, please, I would like to confirm who is supposed to present for group 3, I think. Supposed to present for group 4. Who is that, please? Okay, okay, please. Okay. Question each, and then would also be making the presentation. Let me see.
Hello.
Yes, sir.
Okay, I'm sorry. So I'm just switching the
internet.
Yes. So what I noticed, the other one wasn't working. Okay, so I'll just continue from here.
Okay, sir.
So another important issue is the issue of geographical indications, which is also important to Africa. I mean, we have a wide variety of traditional products, knowledge, production processes, or even products with particular reputation and characteristics that are common to Africa, and internationally, GI has gained currency, so and under the WTO trips, actually, you can adopt different systems to protect GI, whether using the traditional classical patent system or using a sui generis system. But then the sui generis system is more flexible, because for one, of course, it's not bound by the timeline of patent, for example, and then you can also design it to meet the needs of your local community. So that could be Africa making a clear statement about entrenching a sui generis system for GI protection within the AFCFTA protocol, which then forecloses the possibility of an external country, or Western or Asian country, putting pressure on an African country to use a patent system rather than a GI, rather than a sui generis system. Then you can look at it also in terms of protection of plant varieties. We're also saying using a sui generis system would also help us to look at or to place emphasis on the rights of the farmers, the rights of the communities, traditional knowledge, access to genetic resources, and benefit sharing. Not just that you come and poach genetic resources from the forest or from anywhere here, and then you do a research, get something or get modification out of them, patent it, and then the owners of the genetic resources are not able to use even though they were the source of the genetic resources that were used in that. And in this regard, I would advise us, for those who are more interested in this, can look at the African model law on this. It's a clear departure actually from the conventional international system under the UPOV. So the protocol should look at addressing the gaps in TRIPS agreement. Okay, should look at addressing the gaps in TRIPS agreement on relationship between IP rights and traditional knowledge. Now, this, like I said, these were the issues that were canvassed by the African group in the TRIPS negotiations that were not passed, that were not accepted. But there's also moves within the WIPO to negotiate a convention on traditional knowledge, but it's been dragging for a very long time because, well, if the big boys, if the big countries are not interested in it, there's little you could really do to get it working. But then because the AFCFTA IP protocol would also be an instrument that establishes Africa's position for future international negotiations. So we're saying that these issues of importance to Africa should be entrenched within that protocol. Then, we also talked about compulsory licensing, and also the issue of evergreening actually is also very important, and big multinationals know how to do that. So you can, make a slight modification, you claim for additional protection or extension based on that slight modification. And when it comes to especially health products, medicine and vaccines and all that, it's important for us to limit the use of that concept of evergreening for you to keep extending or putting additional protection based on minor modification to the invention. Otherwise, that invention or that product will never go out of patent, and we know the cost implications of that. So there's also, well, I've talked about whether we want to have a supranational system or have a system of progressive harmonization and approximation of existing regimes, and I'll advocate for the latter, a progressive harmonization and approximation of existing regimes based on the agreed principles and standards and timelines that the protocol would set. That's what I think protocol should do. So what are the constraining factors in the negotiations, really? And this is when you look at the entire political economic context, you know, there is this dependence on donors, and that has always been a problem. So when you say you want to negotiate a free trade agreement, you know, or you want to negotiate an agreement of this nature, you have a lot of funding support and technical assistance from all manner of quarters, from the US, from China, from Russia, from EU, and that. And if you're not careful, the support that you receive would hijack your agenda. And I'm in this field, and I understand perfectly how it works, you know. So some of the support, or very few of them, will be altruistic, trying to help you do the right thing, you know. But for the most part, the kind of support you receive have agenda tied to them. So maybe because the country wants you to develop a system that will not put their own businesses at disadvantage, you know. So they support you to get what they want. So it's a risk. And I see it's already happening with the supports we are receiving. But I'm also confident that the AFCFTA process has progressed so far considerably well, irrespective of the support that has come. I think the African government and people have really awakened to their responsibilities to do things that suit their own interest and not the interests of other people. Then we've talked about the issue of conflicting bilateral and regional trade and investment agreements. They are still there, but then the negotiators will have to be very imaginative, and they will need a lot of expert advice and research to be able to find meeting grounds between these fragmented and conflicting systems. There's also the limited legislative capacity, even within the African countries themselves. So for example, if you set a regional protocol, IP protocol, just like we have the regional model law on plant protection, you know, will the African countries have the capacity, legislative capacity to adopt and domesticate those regimes within their national country? We'll see how it has, the conversation about reforming the IPR regime in Nigeria has been on for endlessly now, you know. At least I got to know about it almost around 1990, around 2000, 1999. So I'm sure the conversation was older than that about the Intellectual Property Commission bill. So that's the issue of limited legislative capacity. There's also limited negotiating skills. So the people who are negotiating this agreement at the moment, you know, what is their level of expertise on intellectual property rights? I'm afraid in some cases, there are people who are still trying to grapple with the basic concepts, you know, but because they are civil servants and their duty demands that they will sit on the negotiation, so they do. So those are the things that are constraining the negotiations and most likely affect the final outcome. And then, of course, the issue of limited understanding and all that. So, but this, we could make progress if they would only adopt a more open approach, especially utilizing the existing regional frameworks like ARIPO or using the OAPI, getting them to sit together and then adding some external experts from academia and from all that to try to craft a conclusion to say that the need for a continental approach cannot be overemphasized. It's overdue. Excuse me, long overdue. Now, the present landscape makes it more difficult to achieve that harmonized framework, especially also because different African countries are subject to different external influence. We know the Francophone influence, the Anglophone influence, Chinese influence, American influence, Russian influence, and all these external parties have different agenda. You know, so at the end of the day, you have a potpourri, a collection of regimes, you know, snippets of the American system, the EU system, the French interest, the Chinese interest, you know, coming to muddy the water at the end of the day.
You mentioned to.
So we see that the AFCFTA provides an opportunity for African countries to seize the rein and direct a new course in IPR for African development needs, focusing on those areas that are important to Africa: geographical indication, farmers' rights when it comes to plant variety protection, farmers' rights, issues relating to traditional knowledge. These are real issues that are paramount to Africa, that have not been covered, or that have not been adequately covered within the existing international frameworks that we have. So thank you. That's the end of my little presentation.
Wow, thank you so much, Mr. Leonard. The presentation is compact. There's a lot based on what you just explained. I think some of us have just been reading on the news, reading the newspapers, reading online, and we think that we know a lot. But considering what you just explained, there's a lot of things going on at the back end, and I would like to say well done for the work that you are doing. So I would like you to crave your indulgence to ask the participants, both of them, that's we have two teams that will be making presentations, 5 minutes each. Please, we would just like them to make that presentation, because you've explained everything with so much professionalism. So I'd like to see if they can simplify it and make it very easy to understand, considering that some are students here and
interesting.
Very young lawyers. So let's just listen to what they have to say, and then they'll just go straight to their questions, sir, please. So we'd like to call Grace. Grace is for team 3, right? Or team 4?
4.
Okay, please go ahead.
Okay, good morning, everybody. So I have an issue sharing my screen. So my teammate would help me share her screen while I do the presentation. Omotaya, I don't know if you're ready.
Okay, yes, we can see your screen.
Okay, so I'll just go right ahead. I don't even know if we have much to say regarding seeing that the guest speaker has done justice to the team already. Okay, now I actually have a better understanding of the topic, and I wish we had this lecture before we're giving this assignment, but it's okay. So I'll just go straight to the point. So we already know what AFCFTA means. You know, it means the African Continental Free Trade Area Agreement, and was adopted in March 2018. We have 54 signatories to the agreement, and only 35 of those signatories have ratified the agreement so far. Next slide, please. Okay, so basically we already know that the main purpose of the AFCFTA, I wish there was a way we could call that instead of pronouncing AFCFTA and all, is to promote regional. Okay, so the commitment of the AFCFTA in its attempt to promote innovations and enterprise by regarding ideas and creativity of African entrepreneurs as commodity. Okay, so Article 4 of the agreement is the one that specifically talks about the intellectual property rights and all of that. Now, Article 6 stipulates that the agreement covers areas such as trading in goods, services, investments, IP rights, and competition, that article. So I'll just move to the next slide. Next. Okay, so these are some of the issues we're able to identify. Personally, I didn't quite I read a lot. I didn't quite understand everything I was reading. So, but now I think I do. But I hope that these issues we've been able to bring out part of the issues that are in the AFC AFCTA. Okay, so we've come up with something like diverse IP perspective. Now, let me just read this and explain what I understand by this. Why some signatories to the agreement are actively making legislation to protect IP rights and provide equitable IPR compensations. Others are yet to make proactive actions. This would affect the ratification and enforcement of IP among the signatories. And this is actually true because, like our guest speaker already explained, different countries are different levels of in their IP regimes and all. Some countries are far behind, while some other countries are way ahead. Like he said, Nigeria, we've been grappling with some of the issues in IP regimes. We have not, like the agreement, the AFCFTA agreement, it took Nigeria a while before they were even able to rectify it. And I know that some countries have not even rectified it. So this would definitely affect the domestication of this agreement in some countries. So that's definitely an issue. The issue of legislation, how to domesticate and all of that would definitely affect the speed that the agreement will carry on in some countries. Then we have the implications of advancing technology. So the advancement in technology and data management is still poorly appreciated and regulated in Africa. So unless the e-commerce provisions of the AFCFTA phase 3 regulate distribution of IP-related information online, IP will still be undermined in the continent. So can we move to the next slide? I don't understand that very well. I hope our guest speaker can explain that more for us. Now, there's this issue of facilitating multinational IP regulations. So IP provisions will be binding on all AFCFTA signatories and will regulate the transaction of IP commodities among them. So that there's the issue of how to facilitate these different, our guest speaker has told us of several model agreements that are already in force, but most African countries are even yet to ratify it and also, bring all those agreements together. And so the next issue we're able to distill, okay, this is supposed to be a positive one for the countries that will finally ratify this agreement. So the issue of providing competitive advantage for African entrepreneurs. Okay, so the AFCTA was established to create a continent-wide free trade area, the largest in the world. This common market will provide larger competitive scale for African entrepreneurs and innovators, giving them room to apply their protected IP across 54 nations. Okay, so this is, if this agreement works and if it's properly implemented by the member states, it would help all those countries and everyone that is an entrepreneur in Africa by helping them to showcase their products without much tariffs and custom duties and all those things that seem to stand in the way of people showcasing their products. So I think that's the last slide. Yes, so I think that's the last slide. So that's what we're able to come up with.
Thank you very much, Grace. Thank you. And if you have any questions, just jot them down so that when he's taking questions and answers, you can ask them. So let's go to group 3. Who is supposed to present for group 3?
I am. I'm supposed to present for group 3.
Okay, Opeoluwa, please go ahead.
Yes, ma'am. I'm trying to share my screen right now. So let me try to do that. I'm sorry, I'm coming. I'm trying to share the screen.
Okay.
I'm sorry.
No, it's fine.
Mm. let me just start while I try to share it, because I don't want to waste our time and I'm not getting it. So let me just start. The guest speaker really said a lot of all the issues, and it was almost everything in my slides the guest speaker already mentioned and more. So it was very insightful and I really learned a lot. But then from our presentation, from what we prepared, these are the basic things we did. We are to discuss the issues and prospects for a continental IPR regime. And so we all know the meaning of AFCFTA already, which means African Continental Free Trade Area. And it promotes intra-African trade among African Union nations. We all know, I want to assume that most of us know African Union, AU, and the nations that are in AU, they are all African nations. So this AFCFTA, African Continental Free Trade Area, promotes the intra-African trade amongst these nations, which are African nations. The major issues are in AFCFTA are that it is subject to the principle of territoriality, which means that the national laws of a country, for example, we are all Nigerians, I want to assume, or we are all living in Nigeria. So the laws of Nigeria are supposed to govern the intellectual properties of Nigeria, and this affects the general African continental free trade, because the laws governing Nigeria are not the same laws governing another African country. So there are laws for Nigeria IP, there are laws for Ghana IP, there are laws for Uganda IP. Different laws govern different African trade area. So this is part of the issue, the fact that the laws of the country regulate the conditions for their registration, their protection and enforcement of IP. And it is not the same laws that will go beyond the borders of Nigeria. I hope you understand what I'm trying to say. So the laws at times are not the same of different African countries. And so this is a big issue, because they're all under the umbrella of AFCFTA. Another issue we have is the passive involvement of the government in intellectual property law. Now, this is a general issue in every African country. This is a general issue in every African country, because the government's involvement in the passive involvement, they're supposed to have involvement in ETS, but their passive involvement is now the issue, because it is now most IP laws in Nigeria. We did this last week. The laws of IP in Nigeria, most of it they are outdated. They are not recent laws, or they are not laws that have been reformed. They are not laws that have been reenacted. Most of them were enacted a long time ago. For example, now the laws governing Trademark Act in Nigeria was enacted in 1967. And this was even a reenactment of the UK's Trademarks Act. So that type of law now that was enacted since 1967, this is 2021. That law has not been reenacted, and that is still the law governing trademark in Nigeria, which is under IP. So that's an example of laws that are outdated. And then that is the same law the government is going to use to be passively involved in intellectual property. So that is part of the issues we have with the African Continental Free Trade Area, the passive involvement of the government using those outdated laws. Another issue we have is the infringement of intellectual property rights and the lack of an enforcement system. So there's a lot of infringement on intellectual property rights based on the fact that a lot of people do not even know their rights. A lot of intellectual property owners do not even know their rights. Even the people that know their rights, they cannot enforce it. They don't know the ways to go about in enforcing it. So that is another issue. Another issue is the inadequate policies by the government, which I mentioned earlier, and some states of the AFCFTA on intellectual property. For instance, now in Nigeria, there is no specific body that mandates or oversees the various IP regimes. For example, in the industry, like specific industries, like maybe the music industries, where we have like the the body to regulate that IP in that industry. But it's also different from the ones regulating another industry. So all these things are not uniformed. They are not uniformed. Then another issue is the unwillingness of some member states to domesticate IP treaties. For instance, in Nigeria, the provisions of the Constitution does not allow a treaty to be domesticated automatically upon ratification. That's section 12 of the Constitution that says no treaty between the Federation and another country shall have the face of law except to the extent to which the treaty has been enacted. So that's also an issue under AFCFTA. One other issue is that the fact that some member states are yet to develop a national policy framework that spells out the overall IP goals of the nation. So some states have not gotten to the point where they've taken IP seriously to the point of developing a policy to govern IP generally. That's on the issue. Now moving to the prospects. Prospects are establishment of a set of IP rules which are clear, transparent, predictable, and mutually advantageous to the member states. So these are the things we should look forward to doing. The government should look forward to doing. They should look forward to making predictable and mutually advantageous laws for all member states under the AFCFTA. Also, to boost the inter-African trade, they should promote and create job opportunities among the African industry on global stages. The another prospect is that the trade in goods and services and investment and intellectual property rights would contribute immensely to the talents in Africa and development of the technical know-how of African countries. In conclusion, intellectual property rights is very important and is a very important issue in the African free continental trade area. Thank you.
Thank you very much, Opeolua. Thank you. So just go straight to question and answers. If you have any question, please just kindly unmute yourself and ask your question so that Mr. Leonard can answer them. Okay. Grace, Otuonye, Rita, and Nika.
Okay, I have a question. I did not understand the continental exhaustion policy. And then I would like the guest speaker to also talk more about the most favored nation treatment policy. I also didn't understand that. So if you can just talk briefly on those two.
Okay. Do we have any more questions before you start taking answers?
Yes, ma'am. Good morning. I actually have a question based on the presentation earlier. Mr. Leonard mentioned in passing that some nations are they were worried at some point about the competitive advantage of I am attached to these phase 2 negotiations. And we can also see it in the TRIPS agreement, how Africa was a little bit relegated in the advantages. So how would AFCFTA, how does it think that it can ease the concerns that larger economies or foreign support not cause an imbalance in the competitive advantage of these negotiations?
Okay, thank you. Do we have any more questions? Okay, if you don't have any question again, then let's welcome Mr. Leonard to help answer the questions. Mr. Leonard. Please, can you hear me? Hello, Mr. Leonard. I think his network is really a mess today, as he just said. Okay, while we wait for him to get us, okay, so he's even off. Probably he'll be back soon. But before he's back, please let's welcome Mr. Ayokunle Adetula to give his thoughts on it while we wait for Mr. Leonard.
All right, good morning, everybody. I'm very sure that you've been enjoying yourself and soaking up knowledge. It's beautiful to have, people share knowledge, share experience from researches, and sometimes I guess one of the best ways to really be able to soak up knowledge when you research from not really knowing so much. You just soak in the knowledge, and then it gets good. And I think Leonard has done a good work with his analysis. I didn't join immediately he started, but then I think something I never had either from him or from the other people that presented was traditional knowledge. I know that one major proponents of traditional knowledge have been from Africa and some Asian countries. At least I'm aware Aripu has the Swakopmund protocol for protection of traditional knowledge and expression of folklore. I'm also aware that is one of the places where we are actually losing a whole lot as a continent, Africa wide now. China is ripping us off big time in that area. And I know that efforts in this area are not actually getting the required traction, internationally. So it's my thought also that by the time they are negotiating this AFTA and the IP protocol to it, that this is something that they will actually put in the front burner. I know one of the people that have been key to this pushing is Emmanuel Saki. And I know at least Bible Fora, he has led the push at several during different occasions. So one way or the other, if Africa is able to get a system now that others will probably have to buy into, it should really be good to see the possibility of even institutionalizing something like the Swakopmund protocol across Africa. And then if they are not going to accept it internationally, by the time they come to us, then we'll put it as a signpost, so that you turn print or you get out. So I guess that's something I didn't hear from the discussions, and it may be good for people to get to understand that. And then I don't know, but then I guess maybe something very also interesting, cutting edge wise, to see if we can even get Emmanuel Saki on one of these meetings. Juliana.
Yes, sir.
So I think it may be something I may I may be interested to help you speak to him, and then we can get Emmanuel Saki to, I mean, he's very, very knowledgeable in that area. And if he's going to have time, I think he's now retired. So I suppose he may have time on his hands now, because I know he is usually very busy. But then let's look at that possibility of pushing that to see if he can also come in on these meetings once in a while to share his thoughts.
Okay, sir. Okay, sir. Thank you. Thank you so much, sir, for the perspective that you brought to the discussion. Traditional knowledge and cultural expression is something that is everywhere in Africa, and it's important that we know how to protect it and that we take measures to protect it adequately. I would like to thank everyone that's been here. Mr. Leonard has been having serious network issues, and I'm sure that it threw him out again. But I would like to thank all the mentees that came together to present. One of the reasons that we ask people to come together is because in previous sets, they usually do the assignments individually, and they didn't have time to bond within themselves. So this group assignment is a way to encourage you to bond with each other and be friends, because in this practice, you need friends in the same area that can help you to brainstorm, give you ideas and the rest. Plus, we have mentors that are here that you can have access to even after the program. Thank you very much. So today is tackling the laws and the policies of IP and all that. And I'd like to encourage everyone, because IP is beyond just going to register a trademark, register a copyright, etc. It's the bigger part of it to has to do with policies and all that. And I'm sure that everybody here would like to be called to be on a panel, to be among the policy think tank and the rest. So that's the reason why we try to create something around this, so that you can also learn and have an idea. And if you are called to the table, you will have something to say. So with that, we are going to end today's discussion. We'll be meeting in the evening with Mr. Rama. He was the former director of WIPO, New York, and he'll be talking about IP treaties and how it affects developing countries. I join everyone to be part of it by 4 p.m. today. Thank you very much, Mr. Ayokunle. Thank you for coming. Thank you for sharing. Thank you, Neka. Thank you, Grace. Thank you, Joseph Omotoye, Opeolowa, and Rita. Thank you so much. Have a lovely day, and I will see you all by 4 p.m. Thank you. Bye.
Thank you, Ram.